All right, I think I will just start. I hope we're all ready. Hello,
Yes,
everyone.
I am.
Oh, good.
Yes,
I am.
we are ready. Yes.
Okay, fine. So good morning, good afternoon, and good evening. You can please take whichever applies to you, depending on your jurisdiction. It's a beautiful evening here in Abuja, Nigeria, and I welcome you all to this webinar on trends in arbitration in Africa, organized by the Berkeley Global Society. The Berkeley Global Society is an international organization having direct presence in 90 countries. It is composed of outstanding lawyers and professionals educated at the University of California, Berkeley, United States of America. And the purpose of this webinar is to impact by building analysis and proposing new paradigms. My name is Ayodele Babalola. I'm the lead counsel at AOB Willows LP, Abuja, Nigeria. I'm a member of the Berkeley Global Society and the author of the Nigerian Campaign Finance Law. As the moderator of this webinar, I'm wearing two hats. The first hat is that of a forerunner, and the second hat is that of an umpire. So as the forerunner, I'll be introducing our distinguished experts, and as the umpire, I'll be setting down the rules of engagement. So the invited panelists for today have been carefully selected. They are excellent and super arbitration experts with remarkable experience internationally and also on the African continent. Each of our panelists have 20 minutes for their discussion, and we would have the Q&A session after each panelist has presented their topics for today, which is going to be at the end of the last speaker's presentation. So please let us all ensure that our mics are muted, of course, except for the particular panelists speaking. And please also make use of the Q&A, the questions chat box to put in your questions, and they will be attended to as time permits. So without taking further time, I will introduce our first speaker, the amazing Mrs. Fumi Roberts. She is the founder.
Good evening, everyone.
Yes, you're welcome, ma'am. She's the founder, principal partner, and head of ADR unit at Fumi Roberts & Co., an internationally recognized law firm. She's also the co-founder of the timely COVID-19 ADR initiative, CADRI, an initiative to improve access to and delivery of justice despite the obstacles posed by COVID-19. She's also the chairman of the National Committee on the Reform of the Arbitration and Conciliation Act 1988, Nigeria. She serves as director on the board of the Lagos Court of Arbitration, as well as other several corporate boards. Most recently, she was conferred Chartered Arbitrator of the Chartered Institute of Arbitrators, UK, amongst other numerous achievements. Thank you for joining us, ma'am. So we'll start with your presentation.
Yes, thank you very much, Ayodele, for those kind words. And it's my pleasure to be on this platform. I saw the list of distinguished speakers, and I'm completely awed. Thank you all very much for having me. I always say that I don't like being the first to speak at any event. I always prefer to be the last, because by that time, everybody has all the points have been made. But for the first time in a very, very long while, I'm the first speaker. And I have Ayodele to thank for that. My presentation is actually on something that's very topical, particularly in Africa, and which touches on the subject we're here to discuss. I'm going to talk about Africa as a continent. And I'm sure many people will wonder why that. And it's because even on CNN and a couple of webinars I've taken part in, some people actually think that Africa is a state. And I've had course on some occasions to tell them that no, Africa is a continent with more than 50 sovereign states, with about 3,000 languages spoken. So it's a multilingual continent. In fact, the most multilingual continent in the world. It's a continent with indomitable spirit and recognized since 2016 as the fastest growing economy, second fastest growing economy in the world. So it is by no means a state. And a couple of days ago, I received an invitation from one of our collaborating partners in England, King and Spalding, one of the international law firms in England, inviting me to the September 2020 Africa webinar series. And the invitation had this quotation which struck me. And it's a quotation by Gaius Secundus, that's ex Africa semper alici novi, which in English translates into from Africa, always something new. The text from King and Spalding further says that the quotation aptly captures the ways in which businesses have found innovative solutions to seemingly intractable problems in Africa. And this statement validates the resilience of Africa, even in respect of where the challenges we face in the arbitral space today. There is increased dependence on, or rather acceptance of arbitration as a dispute resolution means in Africa. But in recent times, there's been a clamor for African arbitrations to remain in Africa. There's been an increase in the number of arbitration institutions and bodies all over Africa. And I've given one or two examples. And of course, there's now a greater awareness about the positive impact on the GDP of African countries if rather than export our arbitrations, we do them in locally. But at the same time, we in Africa recognize the need for foreign direct investment. And we must be able to give comfort to those who invest on our continent that their disputes will be resolved in a manner that is satisfactory to them. In recent times, African states have signed so many BITs, MITs, and there's so many non-treaty commercial activities on the continent. With all this investment, increase in investment, increase in international commercial activities, disputes are bound to arise and to increase. And when this dispute arises, more often than not, we have arbitration clauses in the transactional documents. But what is the preferred seats of these arbitrations? The Queen Mary 2015 International Arbitration Survey identified 3 factors that determine parties' choice of arbitral seat. One of them is the national law. Another is the neutrality and impartiality of the civil justice system, as well as the ease of enforcing arbitration agreements and arbitral awards. The challenge we face as African states is that we are competing with established, efficient, and reliable seats for the same space. London, Paris, Singapore, those are the countries that have taken the lead in being the seats for international arbitrations. But I'm going to look at this in the context of not the 3 planks identified by the Queen Mary survey, but on one aspect of it and what we are doing locally to deal with the challenges posed by the national laws of the different African states that are brought into arbitration. Now, I'm going to look at it in two respects. One, what has been our response to the New York Convention? And I'm not going to spend too much time on that because I want to focus more on the national laws. 38 African states out of 50, about 56 African states are signatories to the New York Convention, which shows the whole world that yes, Africa is ready to work with the entire globally to ensure that it complies with international best standards. Secondly, I'm going to look at efforts at bringing national laws to meet internationally accepted standards. And my next slide is going to show you what the position is in Africa as we speak. The countries highlighted in green are those countries in Africa that have arbitration laws that are less than 10 years old. Those in yellow are those that have arbitration laws that are more than 10 years. And you'll find that practically all the states in Africa have arbitration law, whether old or new, except for the Western Sahara, which I may touch on if there is time. So having said that, it's going to be impossible for me to look at the trend in 50-something countries. And that is why I'm going to just pick a few countries that are doing something in recent times and which I think would be of interest to the participants. And I'll start with Tanzania because that's the new kid on the block. From 2015, there's so many protectionism laws passed in the natural resources sector in Tanzania. And most of them prohibit or restrict the use of international arbitration to resolve investor disputes in the natural resources sector. And why natural resources? This is where the attention of the investing partners have been heightened. There were two laws passed at that time. One in 2017, the Natural Wealth and Resources Permanent Sovereignty Act, which prohibits the use of international arbitration to settle investor disputes in the natural resources sector. We also have the Public-Private Partnership Amendment Act of 2018, which says that judicial bodies or other state-recognized bodies in Tanzania would mediate or arbitrate disputes that arise from public-private partnership transactions. And this will be in accordance with Tanzania law. Of course, this met with a lot of resistance from the investing community. And in an attempt to modify this stance, the president presented to the Tanzanian National Assembly the Arbitration Act of 2020. And within a couple of months, that act was passed into law and it was signed by the president. And one would think that that's the end of the story until a couple of months down the line. There was a decision which was delivered by Justice Phillips of the Commercial Courts in Tanzania on June 12th in the case of High Hope International Group, Jiangsu Native Produce Import and Export Corporation Limited against JOC Textile Tanzania Company Limited. It's an unreported case. And the essence of that case is the decision that even though the Arbitration Act 2020 has been signed by the president, it has not come into effect because it has not been gazetted by the minister as required by law. So the effort made by High Hope to enforce an arbitration award was not effective in that case. So I'll now move on to South Africa. I have only 20 minutes to present this. And Ayodele, next time you should give me about an hour because there's so much to say about this topic. But I'll quickly move on to South Africa, where they've tried to strike a balance between state interests and the investors' interests. South Africa terminated many bilateral investment treaties from 2016 and promulgated a new regime for resolving investment-related disputes. And that's the Protection of Investment Act 2018. It came into force in July 2018, and the preferred dispute resolution process for investor-state dispute is to shift from arbitration to mediation and the local courts. And state-to-state arbitration can only be conducted with the consent of the South African government. The pushback on this is also very fierce, but that is the current position in that country. Now, that is not, South Africa is not the only African country that follows this model. Egypt has done the same, and Namibia, I'll talk more about that shortly. But South Africa's arbitration law itself was steeped in antiquity because it was a 1965 law until the year 2017, when it joined the League of Uncitral Arbitration Model Law Countries, when the International Arbitration Act was passed in the year 2017. Now I come to my home country, Nigeria. The map I had shown previously showed that Nigeria was one of the yellow countries, one of the countries that have an old arbitration act. Our current governing law on arbitration is the Arbitration and Conciliation Act, decreed into law in 1988. And when Chief Bayo Ojo, Senior Advocate of Nigeria, was the Attorney General of the Federal Republic of Nigeria, he set up a committee headed by late Justice Olakunle Orojo to look into the Arbitration and Conciliation Act and look for ways by which it could be modernized. They came up with a bill which was presented to the National Assembly. Unfortunately, the National Assembly didn't pass that bill into law. And then 3 years ago, the entire arbitration community in Nigeria set up a national committee for the reform of the Arbitration and Conciliation Act to deal with modernizing and bringing the Arbitration and Conciliation Act into modern realities. And yours truly happens to be the chairman of that committee. One of the products of the work of the committee is a bill for the repeal and reform of the Arbitration and Conciliation Act. That bill has passed the third reading at the House of Representatives of our National Assembly. Now, I cannot take you through the gamut of a 170-page document, but the one thing we have done as a committee was to look at international best practices, even though the basic premise is still uncitral model law. We still remain an uncitral country. But what we did was look at international best practices, because even the model law itself is due for an overhaul. And there's so much going on in the arbitration space that not to have looked into other jurisdictions would have been a great disservice. But I'm going to pick on a novelty, which I don't think any other African country has ever thought of, even in developed economies. And that is the Arbitration Review Tribunal, which we made a part of the bill before the National Assembly. Now, one of the questions raised in the Queen Mary study in 2015 was this, that should there be appeals in international arbitration? And this was posed to the in-house counsel subgroup. And they said that the lack of the consensus was that the lack of an appeal mechanism on the merits was one of the frequently selected worst characteristic of international arbitration. Another question posed was, how should a potential appeal mechanism in commercial arbitration be structured? 26% said it should be another tribunal, and 26% said that it should be the Arbitration Institute, if there is one involved. These are the figures. I won't go through the figures because I'm sure my time is also almost up. And the slides I'm sharing with you, I'm sharing courtesy of one of the members of the technical subcommittee of that committee, Mr. Isaiah Bozimo, who did a presentation on this a couple of years ago at the NBA conference. And how does this award review tribunal work? The aggrieved party would serve a notice of challenge, And the parties or the arbitral institution would constitute the review tribunal, and the review tribunal would endeavor to render its decision within 2 months from the date it is fully constituted. It is not a mandatory provision of the bill. It is a default position, and recourse, if you don't opt into it, you go to the court for the setting aside of the award. But the parties may, by express provision in their agreement, opt in for the award review tribunal. It's novel, and we're quite excited about it. We're looking forward to how it will play out in future, and we're hoping that the National Assembly would pass the bill into law before the end of this year, but at the very latest, the first quarter of 2021. Everybody knows that there's been a slowdown in activities globally because of the pandemic. But I would hesitate to finish my presentation without talking about Africa and mediation. As I said at the beginning, we're trying to localize international investment and commercial disputes. And in the last couple of years, there's been a rise in the use of escalating dispute resolution clauses, which makes mediation the step before arbitration. And I'll give a few examples of some African countries that have effected this. I'll start with Namibia. The Investment Protection Act of 2016 said that investment-related disputes should be resolved either by mediation or the local courts, but arbitration only if the parties have agreed to it in their agreement. In the Ivory Coast Code, Investment Code of 2018, there will be mediation under the UNCITRAL rules and then arbitration under the arbitration rules of the OHADA Court of Justice and arbitration. Egypt created the Arbitration and Mediation Center in 2017, and investment disputes are administered by that body. Now, I mean, everybody knows about the new initiative to harmonize trade within Africa, and the African Continental Free Trade Area Agreement came into force a couple of months ago. And the dispute resolution regime ensures that mediation plays a big role in that space. And I won't go through that. The rules are not published yet, but I know as a matter of fact that mediation, which really is actually part of our culture before modernization came to Africa, Africans are used to resolving disputes without recourse to the formal system of justice that we know now. So using mediation as a basis for dispute resolution regime in AfCFTA wouldn't come as a surprise to anyone. And then we have the draft Pan-African Investment Code, which is African Union's framework for an inclusive and sustainable development for African states in a manner that promotes unity and harmony within the continent. In the code, the dispute resolution makes mandatorily a negotiation or mediation period, and arbitration may be conducted, and if it is to be conducted, it must be conducted by an established African public or private ADR center. Now, let me quickly move on to, I know I have just a few minutes left if I've not overrun my time. The Singapore Convention, which is the United Nations Convention on International Settlement Agreements resulting from mediation, was opened for signature on the 7th, I think, yes, 7th of August, 2019. And on that very first day, a significant number of African countries signed the Singapore Convention. The Singapore Convention would become effective when it is ratified by 3 countries. Qatar was a third country to ratify it a couple of months ago. I think Saudi Arabia just recently also ratified it. And by the 12th of September, the Singapore Convention is going to become effective. And what we have done in the bill I'd earlier mentioned for Nigeria is to incorporate the Singapore Convention into that bill so that once the bill is passed, Nigeria would have ratified the Singapore Convention. As at today, to the best of my knowledge, most of the African countries that have arbitration law of one age or the other have signed the Singapore Convention. And I have absolutely no doubt in my mind that the Singapore Convention is going to change the narrative for Africa. And as more and more people become aware of the effect of mediation, we're going to look at it again from the effect it will have on the practice of arbitration on the continent. I'll rest my case here with the hope that I would have more time as we progress to make more intervention on this subject. Thank you very much, Ayodele.
Thank you very much, ma'am, for your outstanding presentation and for indeed your contribution to progressive legislative reforms for arbitration on the continent. One keynote from your presentation is that we recognize the need for FDI in Africa, and we must give comfort to investors to ensure that their disputes can be resolved effectively, even here on the continent. So having said that, I think it's time to move to our next panelist, Abdelaziz Amhawi. He's the founder of the leading Moroccan law firm, Amhawi Law Office, having both domestic and international practice. He has built an international reputation of being a remarkable lawyer with vast experience in the Moroccan legal market. He will be sharing his wealth of experience with us with respect to arbitration in Morocco. Thank you for joining us, Abdelaziz.
Thank you, Ayodele. Thank you very much.
Okay, so I have a few questions for you. What is the legal framework for arbitration in Morocco like? Can you kindly elaborate on this?
Sure. But first of all, let me thank you warmly, and BGS especially, and you, Ayodele and Oba, to your kind invitation to join this honorable panel. This is an opportunity for me, and it's a pleasure and a great honor. Concerning the legal framework of arbitration in Morocco, and by Morocco, I mean the whole Morocco, not always the so-called Western Sahara, but for us, it's Morocco. I'm not going to argue. I'm going to open and close the door immediately, but Morocco for us is Morocco. Anyway, concerning the legal framework of arbitration in Morocco, I would say that the lawmaker here in Morocco has done a pretty good job. There is a whole chapter in the Moroccan Code Civil of Procedure consisting of more than 70 articles devoted exclusively to arbitration, whether it's national, domestic, or international arbitration. And this chapter is not a separate law or something that has been commended by opportunity or to meet specific goals to promote investment. It is a part and a full part of the heart of procedure, which is the Code Civil of Procedure. So it is a chapter, an important chapter within the global rules of procedure applicable in Morocco. And within this chapter, all the most important aspects related to arbitration are addressed. I would say they are addressed extensively, and they are addressed clearly, as well as the key principle of arbitration as they are known and practiced everywhere in the world. There is a definition of arbitration, of course. There is a list of matters subject to arbitration and those who are not subject to arbitration. There is the recognition of the autonomy or the independence of the arbitration clause. There is the recognition of arbitration performed by its private institution or arbitration organized by the parties themselves. There is a recognition of the domestic as well as the international arbitration. There is several rules when the arbitration procedure is organized by the parties themselves. There is several rules related to the way to constitute an arbitral court, the rules of procedure before this arbitral court. There is several rules organizing the effects of the arbitration award, and in particular, it is final and binding, subject to enforcement. There is as well several rules applicable to the procedure and enforcement. And the global spirit is that the parties have a wide range and room of freedom to organize within the public order, the public policy, the arbitration procedure, including, for example, which is important, the language and the place of arbitration. So to answer in a few words and to summarize what I have said right now, I would say that this framework, as it is now, provides a comprehensive and effective and a workable basis for a satisfactory development of arbitration in Morocco, whether it is related to national or domestic dispute or related to international dispute.
Oh, thank you for that succinct answer. So I would follow up with a question about the state of Moroccan case law with respect to arbitration in Morocco, because your first presentation was about the statutory body. So what about the Moroccan case law?
I know this question is important because the efficiency of arbitration needs and suppose that the state court respect the awards. Otherwise, it's needless to go to arbitration. And in this regard, I would say, this is my opinion. I would say there is no bias from the Moroccan courts toward arbitration. Whether the award is issued by an international court of arbitration or by the national court of arbitration. I will even argue the opposite. The reality is that the legal framework that I have just described to you is so strong, so precise, that it's able as itself to prevent any attempt to weaken the arbitration. There is no room for the judge to try to weaken the award that is presented to him for enforceability. For sure, the judge has the right and has the power, and he has the duty, more than the right and the power, has the duty to review the award and to check that this award has been issued in respect with the fundamental principles applicable to any exercise of granting or giving justice or saying what is the right, what is the wrong. And these principles are universal. Everybody knows them. Every judge knows them. There is the rights to respect the defense and to give fair room to any defense to develop and argue with full liberty, full freedom during the whole process. And there is, there's many principles, but for me, these two are the principles and the most important. The respect of the defense rights and the obligation for any arbitrator or for any court of arbitration to fully and properly motivate the award. Why that? Because the judge, as you know, has not the right to check again the substance of the award. The judge has to respect, and in Morocco, they respect the power of arbitrator to settle the case. They are not going to check again. It's not a court of appeal. But they have to check the compliance of the way the justice or the award have been issued in respect with these fundamental rules. And if it's okay, if the checklist at the end of the day said these guys have done their job, whatever they have said, because they were free to say what they had to say. This was their mission. Then the enforcement is granted. And there is something that may rise to the thinking, which is the right of any judge. I think the rule exists in many other systems of law to check the compliance of the award to the public order. And this is, in sometimes leaves the room to some judges, or in the spirits of some guys, to say, well, even if we did our job correctly, they're going to take the opportunity to argue that the public order, what is the public order in Morocco? What is the public order in Algeria? What is the public order in Nigeria or elsewhere? And they say you have breached the public order. And with this regard, I would say that giving or starting from the point that, at least in matter of business law, since the public order, when we are talking about business law, is rather the same, because we're talking about freedom of enterprise, we are talking about the protection to be granted to the property right, we are given the protection of mortgages and creditors. We are talking about some principles that are common or not slightly so different from a country to a country, talking about business. So there is no room, in my guess, in my thinking, that there is a risk in Morocco of contradiction between an arbitral award issued in matter of business law, whether national or international, and the so-called ambiguous, nobody knows what it is, and even the judge, let me tell you, don't know what it is exactly, the public order or the Moroccan public order. So to summarize the answer to this question, if the arbitrators do correctly their job, if they stick to the strict respect of the defense, if they motivate correctly and properly and exhaustively and precisely, being said that they are free to judge in the language the party have chosen. And the sentence, if it's not issued in Arabic, it has to be translated to Arabic in enforcement. So even the arbitrators are free to deliver a sentence written in let's say in Chinese, for example, and the party who claim enforcement has to translate it to Arabic. So if these key principles are respected, then the Moroccan courts will not go against an award issued by a competent, professional, and high-skilled arbitration court.
Thank you, Abdulaziz. I want to assure you that the ugly head of public order or public policy rears in several other countries, not just Morocco. So I would move to...
It's a nightmare everywhere. It's a nightmare for everybody.
So I would move to the next question, and that would be about the acceptability or popularity of arbitration as a means of dispute resolution in Morocco. Tell us about that.
Okay. So to this question, I would tend to give a mixed answer. I will not be clear. It's not white, it's not black, it's a gray zone. Why? Because in my opinion, the success of arbitration relies on 5 key factors. I say 4, but it's 5. The first one is an appropriate legal framework. We've talked about it. Here in Morocco, it is met. We have this condition, no question about that. The second condition is a case law in favor of arbitration and not against arbitration. A case law that has no bias against arbitration, that is not in competition against arbitration. We have this condition met in Morocco, second condition. But in my opinion, there's still 3 conditions, at least. First one is that the contracts for which the final issues justify arbitration because of the cost involved. We're talking about a domestic market. We're not talking about a market of the size of a continent or half continent or quarter of continent. even if we're talking about international dispute or international difference, there's, let's say, just I don't think somebody has done the job unless at least I don't know what would be the result of such a survey. But let's say if there is 10 contracts that are eligible to arbitration, maybe 3 of them will reach the threshold or the size to justify to stipulate an arbitration as a way to settle the difference. And for these 3, maybe, as you know, not all the contracts raise to dispute. Maybe one of them raise to dispute, leads to dispute. And not all the dispute leads to arbitration. So if you narrow the way to say how is the probability of the arbitration to be an effective and a kind of well-known and day-to-day way of dealing with disputes, at the end of the day you will result with 1 or 2 cases of arbitration, let's say in a year. For sure, there is no doubt that international contracts as well as high-stake local contracts systematically contain an arbitration clause, because investors coming from outside, there's no question about that. They say arbitration, it's like the evangelists, it's like this, and no question, no discussion. And for Moroccan contractors, when it comes to a certain high stake or certain financial issue, then the legal advisors generally recommend the implementation of an arbitration procedure. So I would say that it's really subjective, but I would say that below $500,000 as a financial issue, there will be no place for arbitration. And beyond this issue, $400,000 and more, then people may think about arbitration and the interest of arbitration and the benefit of arbitration, because it's something that may be justified by the benefits of the arbitration against the cost of arbitration. The 4th condition, which is important as well for me, is the knowledge of arbitration and its mechanism. Everybody talks about arbitration, especially lawyers. And me, myself, I was used to talk about arbitration. And let me tell you that I'm learning every day, and I've done mistakes. And I would like to still commit some mistakes because I'm learning from the mistakes. What about people who are not used to this mechanism? So in this opinion, in this regards, my opinion is that there's still a significant work to be done, because there are still many misunderstandings about arbitration. And every lawyer knows what are these misunderstandings, because they are classic, I would say, and quite common, such as the confusion between the place of arbitration and the applicable law, or more common and more funny sometimes, the confusion between the role of the arbitrator chosen by a party and the role of this party's defense. So the arbitrator is not your defender, he's not your friend, he's your trustee, he's your man you trust, but once he belongs to the arbitral court, he joined another world. He joined the world of the court. And he lives the world of friendship or knowledge or reputation, if there was. And I would say specifically to Morocco, there's a fifth condition and the final condition, which is important, especially when we're talking about areas or even limited jurisdictions. It is a sufficient pool of potential high skills arbitrator to facilitate the choice and to avoid multiple conflicts of interest. because it's good to have legal framework. It's good to have a favorable case law. It's good to have the opportunity to go to trial. It's good to have a good knowledge of arbitration. But if you don't have arbitrators, and if you always have the same arbitrators, the same figures, the same people, it becomes to be difficult. Although the guy has to be a permanent arbitrator, or the group, or this narrow range of people has to specialize themselves and stop doing everything in their professional work except arbitration, or there will be day to day, year after year, a kind of problem because you pick, or you have to pick always the same people. So I would say in Morocco that arbitration is well known. It is, I would not say it is popular. I would say it is well known. I would say it is reserved and dedicated to the highest, best contractual practice. I would say that there is still work to be done to give a better knowledge to everybody who is involved, or maybe involved or interested in arbitration, of what is arbitration. And it needs, in my opinion, to be really improved and to make a step ahead from what it is now to what it could be in the future. It needs to enlarge the panel of arbitrators here in Morocco, at least, so we can have the choice and the opportunity to pick without any difficulty or without any headache high skills arbitrators when it is necessary.
Thank you again, Abdulaziz, for your response. So I would just chip in one more question, then reserve whatever I have for the general Q&A. And so this one would be, whether there are any recent initiatives in the ADR community in Morocco that came as a response to the COVID-19 pandemic.
I would say there were two responses. First one is that professionals have become aware that within such circumstances where, in particular, the courts is almost closed, it is en panne, like France says, meaning the ship is in the sea, but there's no wind, so the ship just stopping here, waiting for the wind, which is our situation here. Then people became aware that if there were arbitration, it would have been possible to move ahead and to not wait for the courts to start working again, to set up or to settle the cases that now, unfortunately, that are pending for months and months. So now people become aware that arbitration could be one of the solutions to solve this situation of non-working state courts because of the COVID situation. And another reaction for the in progress procedures of arbitration was quite natural. It was even a suspension of the procedures because, for example, one of the parties was able to provide its efforts, its submissions during the normal period, and the other party had to do the same job, but in the middle of the crisis. So in such circumstances, for as far as I know, and it was my case and others friends, we have asked and obtained the suspension, the temporary suspension of the procedure. And for others, it was just an authorization to exchange submissions by electronic, by mail, instead of bringing the papers to the cross the street and bring the papers to the court in the other part of the other side of the street. Other than that, no. It is the crisis. This crisis is the kind of crisis that you have an idea every day. So we have to wait some period to summarize and to integrate and to take the benefit and all the consequences of all this situation to have something efficient.
Thank you, Abdelaziz, again for your excellent presentation. It's good to learn that Morocco is taking giant strides to support the arbitral process. Thank you again.
Thank you.
So we'll be moving on to our next panelist, and he's Duncan Bagshaw. Duncan Bagshaw is a partner at Howard Kennedy LP in the United Kingdom. He specializes in international arbitration and litigation, with particular focus on the energy sector and Africa-related disputes. He often advises on issues ranging from, or issues arising from joint ventures and commercial contracts. He'll be discussing on the topic, addressing and challenging perceptions around African arbitration and arbitrators. And his presentation is going to be conversational. Are you ready, Duncan?
Good evening, Ayodele. Can you hear me okay?
I can hear you very well, loud and clear.
Thank you very much. I've heard it said that it's very bad form to begin a presentation with an apology, but in stereotypical English fashion, I should begin by apologizing for appearing by telephone and not by video. All I can say is that it's a reflection of international arbitration practice when you find yourself taking advantage of a brief window when travel is possible and making an urgent trip at short notice, which means that the data available to me would make video conferencing unreliable. I hope at least this way you can hear me clearly and you can hear my words, even if you don't have the dubious pleasure of being able to see my face at the same time. As you said, I'm going to talk about addressing and challenging perceptions around African arbitration and African arbitrators. It's a great pleasure to have been invited to speak, and I'm very grateful to the Berkeley Global Society and to you, Ayodele. It's a difficult subject for me to talk about as a British person speaking from London, but I think it's a suitable subject because in many ways we are part of the problem as one of the large international centres for hearings and resolution of international arbitration disputes. So I'm going to offer a few thoughts, and I hope there will be some questions, answers, perhaps even disagreement, and that it provokes some chin scratching amongst you all. I start by mentioning some familiar statistics which paint a dual picture, because on the one hand, the statistics tell us that Africa is a stronghold of arbitration. We know, for example, that Nigeria is one of the largest national memberships of the UK Chartered Institute of Arbitrators. And as we heard, Funmi Roberts, who spoke first, has recently become a chartered arbitrator, and she joins several of her distinguished colleagues in Nigeria. African parties also represent a large proportion of the parties to cases in the major international centres, such as the ICC, where they represent about 10% of the parties, LCIA in London, where they're over 5%, and ICSID, the International Centre for the Settlement of Investment Disputes, where African parties represent about 22% of cases. It's also the case, as Funmi mentioned earlier, that arbitration is deeply rooted in African legal tradition, both in traditional African practices and in the predominantly English and French legal systems that were imported during the colonial era, but which now form significant parts of national laws across the continent. So we're dealing with a continent that is undoubtedly strong in arbitration, but in spite of that, the other picture that we see is that less than 4% of arbitrators in ICC cases appointed are African, and that less than 3% of arbitrators in LCIA cases are African, and that the proportion of African arbitrators in ICSID cases has actually been declining in recent years, 2017, 2018, 2019, principally because of the retirement or passing of a very small number of senior African arbitrators. So, Ayodele, this is a rather gloomy picture in terms of participation of one of the largest and most significant continents in the world in what is supposed to be the most legitimate and neutral international dispute resolution process.
Yes,
Yeah.
I agree. So, but what actions can be taken to address this? What do you make of the initiatives? And
Yes, I have been significantly involved in observing and participating in initiatives that have tried to examine why there is a disparity in the representation of African parties to international arbitrations as against the representation of lawyers, practitioners, and arbitrators, and also to say, what can we do about this given the concerns that it raises for the legitimacy of the process? The process is only as legitimate as it is perceived to be by the parties. And whilst there's a disparity of representation, that legitimacy will never be as strong as it should be. I've identified a few aspects of the modern international arbitration process which are beginning to reflect changing perceptions. And certainly I see amongst my colleagues outside of Africa who are doing a significant amount of work on African-related arbitration, there are green shoots from which we hope those perceptions will ultimately reach an acceptable situation. To give some examples, within African jurisdictions, there is a significant movement, particularly by governments, to require African participation in dispute resolution proceedings. This follows local content requirements in businesses. It follows local content requirements, particularly in certain sectors, for example, in oil and gas, through the Nigerian Oil and Gas Industry Content Development Act and other similar legislation in African jurisdictions. I understand, for example, that Lagos State in Nigeria will generally mandate arbitration seated in Lagos for contracts involving government projects. Those movements which reflect the desire of the African parties have been reflected by significant professional moves globally to reflect the desire of all participants in arbitration to have African lawyers and arbitrators better represented. I'll give you some examples. This year, a new initiative was announced called the African Promise. This is the brainchild of a friend and former colleague of mine, Kamal Shah, who is in London, a partner at Simmons & Simmons called Stuart Dutson, who is Australian but spent a lot of his career living in Africa, and a Nigerian academic called Emilia Onyema, Dr. Onyema. They have asked international law firms to sign up to take steps reasonably available whenever possible to ensure that there is fair representation of Africans on arbitration tribunals and in institutions and on committees, which I think is an excellent initiative, and it's beginning to get a significant amount of traction. There's also very good progress by African organizations. That's not to say organizations of people like me in London who work on Africa, but genuinely African organizations like the African Arbitration Association, which promotes African arbitrators and African practitioners. There's also moves to reflect the significant role that the African diaspora can play in African arbitration, such as in the US. There is a move to list, identify, and acknowledge African origin arbitrators and arbitration practitioners. There's a particular project that's been started by Simpson Dispute Resolution, which lists arbitrators of African descent. So there's real positive signs. There are still significant challenges, though, and I identified two particular challenges. One is that there is still a significant perception outside of Africa that arbitration involving African parties is still significantly affected by problems of corruption. Now, I don't necessarily mean problems of corruption within the arbitration process itself. What I mean is the role of corruption going back to the contract itself or to the underlying facts which are being argued about, which often give rise to very protracted and lengthy disputes, which parties then exploit in some cases or legitimately raise in other cases, and which take a very long time to resolve. I'll give you three famous examples of that. One is the Kenya duty-free case, which was litigated at great length in an ICSID tribunal, and that contract was found to be void by virtue of the corruption which provoked the contract to be entered into. The second was a case that I did significant work on called IPCO and the Nigerian National Petroleum Corporation, a case that went on for about 14 years before it finally settled, most of which time was spent arguing about corruption in the arbitration process in Nigeria. And the third is an ongoing case called Process and Industrial Development, P&ID, against Nigeria, in which Nigeria has recently been given permission to argue in London that the contract for the construction of a gas processing plant and the sale of the gas was entered into as part of a corrupt scheme. So corruption is an issue which still causes great disquiet amongst international parties and causes a reluctance to go to arbitration in Africa and with African parties. The other problem is that institutions in Africa, even though there's been a dramatic increase in the number of institutions, and there's been a very large increase in the use of institutions on the continent for international cases, there's still only a very few institutions on the continent which are internationally recognized and which handle a significant number of international cases. I should mention of those the South African Arbitration Centre, AFSA, which handles a lot of cases involving South African parties against foreign parties. I should give an honourable mention to the Kigali International Arbitration Centre, which is picking up around 30 new cases per year, but many of them are Rwandan cases only. And I should mention the two arbitration centres in Mauritius, both of which are now quite active. One is called MIAC and one is called MARC, M-A-R-C. Nigeria has several centres of its own which are growing in strength and sophistication. The challenge with these centres is to reassure and to convince international parties that the centres will appoint and supervise arbitrators to the same level and with the same international standards that are applied by centres outside of Africa. And that is still a negative perception held by many parties. I'm going to close with a positive note, if I may, before I stop talking, and that is to recognise what I perceive and what I think my colleagues outside of Africa perceive as a very dramatic increase in recent years in the extent to which African practitioners are actively involved on the council teams and amongst the arbitrators of large international disputes. I'll mention a couple of examples, but there are many, and there are many that I can't mention for confidentiality reasons. Two which spring to my mind are, firstly, that a very large number of cases involving Egypt, the state of Egypt, when they are commercial disputes rather than investment disputes, are being handled by the government's own in-house legal team, sometimes with a small amount of support from an international lawyer, which I think is a development that could be picked up on by other in-house government teams. The second example is cases like the Wallam case, which is an ICSID case brought against Kenya for about $300 million, recently resolved in Kenya's favour. It was very notable that in that case, on both sides, the council teams were represented by both international firms and Kenyan firms, and that the Kenyan firms played a very significant role in the advocacy and the preparation of the case. It's also notable that one of the three arbitrators was African. That's been published. That was Swithin Munchentwali. He was not appointed by the African Party, ironically, so that one sees there is evidence of African arbitrators beginning to be appointed even from outside the continent. I'll conclude by saying that African practitioners and African arbitrators have a wonderful opportunity to take their place on the world stage at this point. The desire is there, the initiatives are there, the expertise is undoubtedly there. There are just some overhanging prejudices which need to be addressed, but which are being addressed. So I think, although we have some gloomy statistics, the news overall is good. Ayodele, I'll hand back to you at that point, unless you have immediate questions. Otherwise, I'm happy to take questions at the end.
Oh, thank you, Duncan, for your precise presentation. Yes, of course, there are follow-up questions, but I will be happy to leave them till the general Q&A session. I'm happy that you were able to join us. And of course, I agree that we all have roles to play in challenging perceptions around African arbitrators and arbitration. Thank you again for your presentation.
My pleasure.
So I'll move ahead to our next panelist, the exciting Abayomi Okubote. Abayomi is a senior associate and team leader in the international arbitration practice of Olaniwa Ajayi LP, Nigeria. He's the executive director of the Africa Arbitration Academy and founder of the Association of Young Arbitrators, AYA. He's also a doctoral candidate at the Queen's University, Canada, where he has been conducting groundbreaking research on third-party funding in international arbitration. He will be speaking on third-party funding in Africa, in arbitration in Africa, and his presentation is also going to be conversational. I would ask him questions and he would give his apt responses. Abayomi, are you ready?
Thank you. It's my pleasure to be here, Ayodele. Thank you for inviting me. And always a pleasure to share the same stage with Mrs. Fumi Rabat, who is one of our mentors in the arbitration space in Africa, and with Duncan Bakshaw and Abdulaziz. Thank you.
You're welcome, Abayomi. Abayomi, one of the recent trends in international arbitration is third-party funding. Notwithstanding its benefits, third-party funding has been criticized by many experts, given the associated risks. So what are the benefits of third-party funding and how can these associated risks be sidestepped?
Thank you, Ayodele. My pleasure to be here. Let me just quickly share the screen so that participants can see my slides. Okay. Can you see the slides now?
Yes, I can.
Great. My pleasure to be here again. And I'll be speaking today on third-party funding in international arbitration in Africa. I find third-party funding to be quite exciting. Lots of issues arising or implicated by third-party funding, but those issues can be sidestepped. And I will be taking us through the upsides, the benefits, and the downsides of third-party funding and what we need to do in Africa to benefit from potentials. For those that are not familiar with the funding arrangements, to know what third-party funding is, and to also identify the opportunities and the policy concerns thrown up by funding, as well as discuss the third-party funding potentials in Africa. Now, going to the definition of third-party funding, and as you can see from the slide, third-party funding is an arrangement between a party and a funder, whereby the funder agrees to cover the cost of prosecuting a claim in exchange for a certain percentage of the proceeds to be derived from the proceedings. And the next question is, why third-party funding? As international arbitration continues to develop, so does its procedural complexities and the attendant costs. And sometimes the cost of discovering, screening, and presenting detailed factual and technical evidence can be unavoidably steep, such that sometimes valid and meritorious claims may never be commenced or conveniently proven because of the significant cost. Although we know that legal costs are often recoverable by a successful party in international arbitration, but we all agree that cost recovery is highly unpredictable, and in any event, the claimant may run out of money before it can fully prosecute its claim. So third-party funding is useful in facilitating claims that have merit but will otherwise not have been pursued simply because of the cost. It has emerged as a means of providing access to capital and leveling the playing field between applicants. So claim holders may also avail themselves of third-party funding. What we are seeing in recent time is that third-party funding is not only available or useful to cash poor claim holders. Solvent companies can also utilize this financing arrangement to mitigate this downside risk of an unsuccessful claim and to maintain balance sheet solvency. We all know that financing of arbitration costs are moving risk of corporate balance sheets may be efficient from the accounting perspective. Now, in addition to the traditional single case financing one claim, we've started seeing in recent time portfolio funding or portfolio financing, which is the financing of portfolio of cases that span numerous clients or law firms. So portfolio funding helps to distribute risk across multiple claims or multiple disputes. Most times, what they do is to use the high value claims in the portfolio as collateral to finance other cases in that portfolio. And for claimants, adding their claim to a funder's portfolio is very attractive for financing business operations, obtaining immediate payment on an award, and covering premiums on an insurance policy against potential non-enforcement of an arbitral award. So, in terms of the legislative framework for third-party funding, out of the countries around the world, we have about 2 countries that have permissive statutory framework on third-party funding. And those countries are Singapore and Hong Kong is not a country, it's a jurisdiction, 2 jurisdictions, Singapore and Hong Kong. Those 2 jurisdictions have laws, national laws on permitting the use of third-party funding in international arbitration. And the third country that is aiming to have third-party funding in its national law is Nigeria. And one thing Mrs. Robo did not mention during our presentation is that one of the innovative provisions of the Nigerian Arbitration and Mediation Bill, which committee she chaired, one of the innovative provisions of that bill is the part that relates to third-party funding in international arbitration. And once that the bill in Nigeria, arbitration bill in Nigeria is passed, Nigeria will become the 3rd country around the world to have permissive statutory framework on third-party funding. We also have some bilateral investment treaties and free trade agreements that have provisions on third-party funding, as you see in Article 8 of CETA. There are 2 draft PITs that have provisions on third-party funding, which are quite useful. There are also arbitration institutions rules, the IBA guidelines on conflict of interest, which is very relevant when it comes to determining the conflict of interest or regarding the relationship between an arbitrator and a funder as to whether that in a way affects the conflict of interest, the independence and impartiality of the arbitrator. We have the Singapore Institute of Arbitrators guidance for third-party funders. The ICC guidance note is also very useful, and the guidelines issued on third-party funding issued by CETAC. Now, we are getting to the meat of it, and which is a question Ayodele asked. Third-party funding, what are the upsides and the downsides? And the way I've conceptualized this is to look at third-party funding as the good, the bad, and the ugly. Now, for the good side, third-party funding, like I've explained, helps to provide access to justice, to cash poor and impecunious claimants. It helps to lessen the impact of claim on cash flow. It reduces systemic inequalities. Typical David and Goliath, where you have a big multinational with solvent balance sheet, big money in the account that is able to finance a claim as against a developing country that is not able to afford such claim. And we have third-party funding, providing so much benefit to claim holders. And I'll move to the bad side. The bad side of third-party funding funding. And this, I pick from some of the arguments that people have raised, or experts have raised, or stakeholders have raised against the use of third-party funding in international arbitration. And one of them is that third-party funding helps to stir up frivolous cases, because where there's opportunity or ability for you to access finance, it will help to, it may trigger the filing of frivolous cases. Although on the flip side, there is an expert in Australia, his name is David Chen, that did some survey in Australia, and the conclusion of that survey was that third-party funding actually helps to prune down frivolous cases as opposed to stirring up frivolous cases, because funders are not going to put their money or put their investment where they will not be able to make good returns. So then another argument is that it adds extra complexity to settlement discussions because of the interest of the third-party funder. Settlement discussions becomes very complex. There are also arguments around commodification of claims. That is as it relates to some of those arguments. But we have some other implicated issues, arising from third-party funding, and one of them is the conflict of interest. And how does that? I would like to unpack that. So the concern is that there may be a relationship between an arbitrator and a funder, which may impact the arbitrator's impartiality and independence, and that third-party funding brings lots of complexity into this process. And there are arguments or questions as to whether there should be disclosure obligation, whether disclosure obligation should be mandatory, and what sort of disclosure should be made. Should it be disclosure as to the existence of the third-party funding arrangement, or disclosure, as to the content or the element of the third-party funding agreement itself? So many rules that are coming up nowadays, rules of arbitral institutions requiring mandatory disclosure. And I see from the proposed rules by ICSID that ICSID is also imposing disclosure obligations on parties that have sought for external financing to disclose at the earliest possible time. There are also issues around whether third-party funding should be considered when the tribunal is granting, making allocation for cost. Should third-party funding be considered as part of the cost of the arbitration for the purpose of the cost award? Can a respondent, for example, rely on the existence of a funding agreement to file an application for security for cost? There are also issues around confidentiality and privilege when a funded party or claim holder is seeking external financing. Typically, they give lots of different documents, including the underlying agreements, to the potential funder. And sometimes the confidentiality of the process is impacted. There are also issues on attorney-client privilege and the extent of the funder's influence on management of proceedings. Now, another big ticket issue is the impact of champerty and maintenance. We see some common law countries have, rules, that based on the doctrine, common law doctrine of champerty and maintenance, third-party funding is not allowed. So that is the bad side. Now let's look at the ugly side. The ugly side, as I've conceptualized it for the purpose of this presentation, is the absence of regulation in most countries and inconsistent rules in some other countries. And the need for regulation was confirmed by the survey respondents in the Queen Mary School of International Arbitration survey, as well as the UNCITRAL Working Committee Group 3, working on the transparency in ISDS. They also identified as one of the big ticket issues, the regulation of third-party funding. And what does it do? Regulation helps to sidestep the implicated issues, and also we are able to take the benefit and sidestep the issues. Now, opinions are sharply divided on the threshold questions. The first question is, who or what should be regulated? Now, should the regulatory focus be on the funders, or on the funded party, or on the arbitrators? The second threshold issue is, what form should regulation take? Should it just be a soft law, or be a hard law, or national laws, as you can see in Singapore and Hong Kong, and Nigeria is trying to introduce? What form should the regulation take? I know Duncan will agree that in the UK, the Association of Litigation Funders have industry regulation, that regulates third-party funders, litigation funders in the UK. Should it be industry regulated or should it be by national law? Opinion are sharply divided on those threshold questions. So those are the bad sides, the good sides, and the ugly sides.
Oh, thank you very much, Abayomi. So let's narrow down on the African continent and third-party funding and arbitration. So marrying this together, what are the potentials and future for third-party funding in arbitration in Africa?
Thank you. That is the typical question I get anywhere I go to speak on TPF. How does it relate to Africa? Can it actually work in Africa? What is the existing regime in Africa? And I think I've spoken to Nigeria, but I also cover some other jurisdictions. And what I thought to do is to look at the different African countries, not all, some African countries, to see what the law, whether they have laws on third-party funding, whether they have judicial precedent on third-party funding, to see what the current state of play is. And I looked at Botswana. The question is, can arbitration be funded by third party in Botswana? And the question is yes. The answer is yes. But there's no legal framework on third party funding as you find in Hong Kong and Singapore. For DRC Congo, arbitration can also be funded by third party funding. There are no rules against funding of arbitration or litigation by a third party, but there's also no legal framework on that. Now, moving quickly to Egypt, there are also no rules or laws expressly permitting or prohibiting third-party funding. Parties typically fund their own cases. It is rare for cases to be funded by third parties. That was what I got from Egypt. But there's a very interesting case of Vichy and against Egypt, which has been widely cited in terms of where allocation of costs was ordered in third-party funding cases. Now, moving straight to Kenya, funding of litigation in Kenya, due to the common law doctrine of tripartite and maintenance, is considered unethical and not allowed. It's unlawful. It is unclear as to whether this rule applies to third-party funds such as financial institutions and whether it applies to arbitration, because the authorities and materials I saw relates to third-party funding in litigation, and sometimes TPF in litigation and arbitration may take this slightly different shape. Now, there's an interesting case again in Kenya, the case of Kotek Mining in Kenya, which also has been widely reported. The case was handled as an ICSID tribunal constituted under the United Kingdom, and that case also relates to third-party funding because one of the parties in that case was actually funded. Now, there are two countries in Africa where you have more robust framework on third-party funding, and those countries are South Africa and Nigeria. For South Africa, prior to 2004, the validity of third-party funding under the South African law was dominated by the historical English doctrine of tripartite and maintenance, which I've explained to. And for the civil law jurisdiction in South Africa, by the Roman Dutch governing Pacta de Quotas Litis. In South Africa, such arrangement prior to 2004 was considered illegal, particularly in those civil law jurisdictions. But the approach in South Africa was altered in 2004 when the Supreme Court of Appeal considered the validity of Champert's agreement in the popular case, and I'm sure some of us are familiar with the case of PwC and Potato Cooperative Limited, typically called the Potato case. And in that case, the court held that third-party funding is not against third-party, inherently against public policy or otherwise void. The court found in favor of upholding the funding agreement and noted that the need for the rules of maintenance and champerty, which are common law doctrines that some countries in Africa have adopted, that's the need for that rule has diminished, if not entirely disappeared. So today, whilst the Parliament in South Africa missed the opportunity to include third-party funding provisions in the South African Arbitration Act that was amended as recent as 2017, but there are authorities from the South African region that shows that third-party funding is allowed because of the fact that it's not unethical and it does not conflict public policy. So now moving quickly to Nigeria. Nigeria also does not have legislation that prohibits third-party funding. However, we have some cases, I think about 3. The popular one out of this popular case out of those 3 cases is the case of Kensington Ego and Okebo, where Justice Ogaku in that case held that where a person elects to maintain or bear the cost of action for another person with the intention of sharing the proceeds of the action or the suit with the person, that such arrangement is champatous. That has always been cited as an authority to say that third-party funding is unenforceable in Nigeria, is illegal in Nigeria. Argument can be made for both sides as to whether you can do third-party funding or not. But thanks to Mrs. Fumi Robert, who gave us the opportunity and the privilege to include in the national new arbitration and mediation bill before the parliament, we now have third-party funding provisions that expressly allow third-party funding, that also expressly abolishes, the thought of champathy and maintenance as it relates to third-party funding in Nigeria, and also provides for mandatory disclosure obligation on parties that have sought external financing. The bill is, I think I had that as past second reading. Hopefully, like Mrs. Fumi said, it will be passed before the end of the year, or the first quarter of next year, by which Nigeria will become the 3rd country that now has a permissive statutory framework on third-party funding in the world. So, a glimpse into the future, just to finally answer this question, is that while international funders with Africa on their radar, these funders believe that growth will be driven by African-based litigation funders. Don't ask me. I'm going to start my third-party funding company very soon. By 2025, experts predict that the size of litigation funding in Africa will be around $100 million with ample room for growth. And there's also sentiment from some other global litigation funders and brokers that this figure will hit more than $1 billion and skyrocket in a few years to come. Litigation funders thrives during booms, and there are potentials that this will work in Africa. What do we need for this to work? To have statutory framework that allows third-party funding, to have very clear jurisprudence permitting third-party funding, to have predictable and stable legal and judicial system that allows third-party funding. And in no time, more funders will come in. Homegrown funders like us, like the company I'm going to start very soon, will also come up, and third-party funding will thrive in Africa. The question someone has asked me during the last presentation I made at the annual conference of the Tanzania Institute of Arbitrators, the question was, who will win the race among all the African countries? Is it going to be Ghana? As we typically see that nowadays, third-party funding is recognized in Ghana, in Egypt, South Africa, and Nigeria. Who is going to lead the pack? Don't ask me again. Nigeria will lead the pack because I'm starting my third-party funding company soon. If you have any question, I'm happy to answer because third-party funding is exciting. Thank you.
Thank you very much, Abayomi, for your knowledgeable presentation. It's always exciting to hear you speak. We eagerly await your harmonized framework for the regulation of third-party funding and also your third-party funding company that you're about to establish. Thank you again for your presentation. So I guess we would move on to the Q&A session now. And I can see a question from Adefumi Lola that is directed to Abdulaziz. She's asking whether Moroccan courts can examine the merits of an award. Abdulaziz, did you get the question?
Yeah, I hear it. No,
Okay.
The answer is clearly no. The Moroccan court, which is a court of appeal that may be in charge of judging what is called a claim of annulment of an arbitral award. For example, by the losing party that is attempting to avoid the execution or the enforcement of a sentence, and such a party that has lost its case shall promptly raise a claim before the Court of Appeal to try to, between brackets, destroy the arbitral award. And it cannot be done under any pretext or any reason. There is a limited range of motivations that may allow the court to pronounce the annulation of the awards. And such motivations, all of them, whatever the case is or may be, are not based on a second analysis or second round on the substance of the matter. This is in all cases excluded. It is not of the power of any court after the sentence have been issued to look again to the case in the matter and say what is or what should have been the right decision, or what has been issued by the arbitrators is a wrong decision. All the power and all the rights and as I said, all the duty of the Court of Appeal is to check if the Court of Arbitrators has respect a limited range of principles applicable to any court, and such rules are applicable to the court itself when it judges on a day-to-day basis. The cases are submitted to the court as a state court. And these principles are always the same. The respect of the right of the defense, the correct and exhaustive motivation, and speaking of arbitration, the compliance of the arbitrators to the mission that have been granted to them, either on the basis of the rules of arbitration, if the arbitration have been issued in accordance to an institutional center, or if it is an ad hoc arbitration, then the court has to check if the award have been issued in accordance to the active mission that is signed between the two parties and the arbitrators as a tribunal. If the arbitrators, once again, respect these guidelines, inside of these guidelines, inside of the territory of the arbitrators as an independent private judges, the court, any court has no right to look, even if it believes as a court that have been done, maybe it's a good or a bad job. It is not its business anymore. So the answer is no. The Court of Appeal, or any court beyond the Court of Appeal, the Supreme Court, has the right to re-examine the merits of the cause or look again to the award in the substance of the matter. So to say things basically, the sentence is final and binding once it is enforceable and once an appeal for annulment is rejected. Full stop.
Thank you very much for that clarification, Abdulaziz, and thank you, Adefumilola, for your question. So this next question would be for Mrs. Fumi Roberts. Do you believe that bringing national laws up to date will be a game changer for arbitration in Africa?
Thank you very much, Ayodele. That question doesn't have a one-size-fits-all response. because there's so many dynamics that play out in several countries. For example, I give the example of Tanzania, where you modernize your law, but at the same time you have laws that deal with specific issues, like the protectionist laws that are passed in those countries. The same thing goes for South Africa. You have a law passed in 2017, but at the same time you restrict the rights to arbitration. So it cannot be a one size fits all, but I can also situate it within the context of Nigeria. I'm a transactional lawyer apart from being an arbitrator and a mediator. And you can imagine sitting with a counterparty and negotiating the terms of a contract. And you get the dispute resolution clause, which is one of the areas my colleagues in chambers invite me to participate in. And you're trying to negotiate that dispute resolution clause and insisting that, look, the country of this transaction is Nigeria. The party, the major party is Nigeria. The subject matter of this transaction resides in Nigeria. Why should we say that the governing law should be British English law? Or when disputes are supposed to be settled, we'll go to England as the seat of the arbitration. And they throw it back at you that, but your law for arbitration is a law passed 30-something years ago. So right now, if we can push the National Assembly to pass this law, one, it will improve the rating of Nigeria on the ease of doing business. And two, it will give transactional lawyers teeth in their negotiations and insist that things, transactions that are African should be heard by Africans. And I can give an example of how this would quickly happen. Abayomi, one of the young lawyers that I have great admiration for, was the chairman of a committee that worked on the African Arbitration Academy's protocol for virtual hearing during the COVID-19 at the peak. And I had the privilege of going through it. And I saw that this is a homegrown solution because it took into consideration all the issues that we addressed when we're dealing with virtual hearings. So a couple of months down the line, we're negotiating an oil and gas contract, and the counterparty had put English law, the usual clauses, and I was able to give them compelling reasons why the protocol we should adopt should be the protocol put together by the African Arbitration Academy. And they saw the wisdom in that, and they adopted it in the agreement, even though we went on back and forth for several months. But because I got them to even have a cursory look at that protocol, I was able to convince them that this is the way to go. And at the end of the day, they agreed with me. So it will give us room to maneuver. It will increase our negotiating power. And at the end of the day, improve our rating on the World Bank ease of doing business. There's so many other benefits. I'm going to share that deal with you, Ayodele. And if there are any participants who want to read it and pass comments to us, we're quite happy to look at the comments. But I can assure you that that is one legislation that will be a major game changer for us in Nigeria. And I can see countries that are also looking at modernizing their laws use that law as a reference. And as I said in the chat, Abayomi was one of those who worked on the third-party funding aspect of the bill. And I thank him for giving me the credit for that, but it's really not my credit because they did all the work, and we had the cooperation of the chairman of the technical subcommittee, Professor Paul Idonije, SCN, agreed to that as well. Thank you very much, Ayodele.
Thank you very much, Mrs. Roberts. Oh, fantastic. So my next question would be for Duncan. Can you hear me, Duncan?
Yeah.
Oh,
I can hear you, yes.
Yes, fantastic. Yeah. So many years ago, you were at the LCIA MIAC, where you did a lot of work to project that institution internationally. An institution on the African continent that has now transcended to the MIAC. Mrs. Fumi Robert alluded to the role the African Arbitration Academy played in the drafting of virtual hearing protocol. What role do you think similar arbitral institutions located on the continent have to play in challenging the perceptions around African arbitration?
That's a very good question and a very important question, because without good institutions, international parties, including parties from other African jurisdictions, will not have the confidence to agree to their arbitration being seated in a given jurisdiction. Institutions give reassurance on many levels regarding the selection of the tribunal to ensure that they are competent and appropriate. Also regarding the handling of procedures to prevent strategic blocking measures or what's sometimes called guerrilla tactics in arbitration to try to slow the process down. And also in relation to fees, to make sure fees are reasonable so that the parties are protected, but also adequate so that arbitrators are willing to arbitrate under the rules of the institution. To give an example, there was a lot of fuss in recent years about the JETMA case, which was handled by the OHADA Arbitration Center, the CCJA. And that was an issue because the arbitrators rejected the limit on fees imposed by the institution. But the institution said, well, if you make an agreement for fees which is not approved by the institution, then the award will not stand and will be set aside. So it can be a huge issue. And institutions are, as I say, an essential part of the process. It's also extremely challenging to get an institution to a level of trust and reputation that it can be relied on by global parties. If you take one of the most successful institutions in the world, the Singapore International Arbitration Center, it was formed in the late 1980s, and it only started getting a significant number of cases about 20 years later. That demonstrates the time and investment that's required to build up institutions. The good news is that progress is being made. The number of institutions is now very high. Sadly, not all of them will be able to be successful, but I think what we'll see is a pyramid effect, where with a very large number of institutions, a top tier of institutions, perhaps one in each of the primary jurisdictions, Nigeria, Kenya, South Africa, Egypt, Morocco, and others, I don't want to be selective, will lead the way and demonstrate reliability, good efficiency, good administration, and confidence in parties. And I think that will have a transformative effect on arbitration on the continent. We're getting there, but it will take time. I hope that's some answer to your question.
I think it does. Thank you again, Duncan.
Thank you.
Excellent. Yes, so the next question will be for Abayomi. I see a question from Kemi that I can tie to my question. So it will be the question will be like a two-in-one question, Abayomi. So Kemi is asking about how the issue of maintenance and champati will be dealt with in the Nigerian bill. But my question would be that with the passage of the arbitration bill, we are definitely going to see a statutory override of judicial decisions on champati as it applies to third-party funding in arbitration. But does this extend to litigation, or is it still under the stronghold of champati judicial decisions as it relates to champati? Abayomi, these questions are for you.
Thank you very much. I'll quickly answer the questions. The first one is how have you dealt with champati maintenance in the bill? What we have done is to adopt the approach used by Hong Kong and Singapore. And what it did was to expressly abolish third-party funding in relation to international arbitration and domestic arbitration in Hong Kong and Singapore, which was the same approach we adopted. So if you look at the bill expressly has abolished third-party and maintenance as it relates to funding of arbitration in Nigeria. And quickly to move to the question that you asked, Ayodele, is that given that the bill is going to become an arbitration law, it does not relate to litigation, and the third-party funding provisions in the bill only relates to arbitration. So the simple answer to your response to your question is third-party and maintenance, once the bill has been passed, will no longer be applicable to funding of arbitration proceedings or funding of arbitration in Nigeria because of that statutory override. But of course, the common law doctrines will still apply to litigation.
Fantastic. Thank you, Abayomi. And according to Mrs. Fumi Roberts, you have been threatening to start this third-party funding company for some time. We need to move this needle, Abayomi.
Yes, Abayomi, when are we going to start?
Mrs. Roberts, we'll take the conversation offline.
Yes, we will.
I can assure you that
I wanted to hold you to it publicly so I can have the 1,001 witnesses. Fortunately,
a potential shareholder in the company. Well,
yes.
the plans are actually, and discussions are ongoing, but we want to come out very, very big. But like I said, we'll take the discussion offline now.
Yes, actually, talking seriously, the reason why it's important for third-party funding to be integrated into our arbitration landscape is the fact that, I'll give a personal example. In the last 6 months, I've had about 5 references, appointments, arbitration appointments. And because the parties were not able to pay, only one of them is going through. And it is such a shame because what is happening is that parties are being deprived of their preferred means of dispute resolution. Of the 4 that failed, it was a panel of 3. And try as I couldn't get my co-panelists to let us bring down the fees beyond a certain threshold. And I can just imagine if we had the opportunity to offer third-party funding legally, it will be a game changer. And as long as there are certain checks and balances put in place, some of the fears that Abayomi alluded to can be dealt with.
Absolutely, which was what we did in the bill. Issues relating to conflict of interest, we've imposed mandatory obligation on funded parties, we've dealt with issues relating to security for cost. I know I had discussions with you and Mr. Shashori on that.
Yes.
Issues relating to allocation of cost. So those issues have been dealt with. Our funders will come. What we're hearing from experts is that lots of money will come into Africa once we have good, permissive statutory framework. And I think Nigeria will lead the pack once the bill has been passed into law. And once the third-party funding we are about to pass comes to life.
Thank you very much, Abayomi, for that. So at this point, we'll be taking the final word from the speakers. And let us start from Mrs. Roberts.
Well, what I'd just like to share is the fact that arbitration has come to stay as a dispute resolution mechanism. So has mediation. And I cannot begin to even tell you the number of mediation meetings, seminars, trainings, and so on that I've attended during the lockdown. And these are dispute resolution processes that are more akin to what we're used to in Africa. And with the Singapore Convention I can see more countries embrace some of the initiatives that other countries have put in place and put mediation in the front burner. And I say this, people would say, but you're also an arbitrator, Mrs. Roberts. I'm an arbitrator and a mediator, CIDA accredited mediator as well. I wear both hats, but I think that it is important for us to give parties the opportunity to resolve their differences in a win-win situation before they escalate to the adversarial. And that is what mediation offers us. And that is what is actually traditional to us in Africa. And I can see it change the narrative. And probably by the time we're talking next year on the same topic, we can then share some figures. And you can actually, your institution can conduct a survey in another 5 years and present a figure to present the result of the survey to the entire world in 5 years' time. Thank you very much. And it's been a pleasure being on this platform. I thank my Odili, I thank all the organizers for inviting me, and I look forward to the pleasure of working with you and even collaborating with you on KDRI, an initiative that is being run by 3 institutions in Africa. Duncan mentioned the need for strong institutions. LASIAC is one of them. ICAMA in Abuja, where you are, is one of them, and the Oyo State Multi-Door Courthouse are all the operating partners of KDRI. Thank you very much.
Thank you very much, Mrs. Roberts. Abdulaziz?
Yeah. Well, while leaving or preparing to leave this great meeting, I would like to share with all of you kind of feeling I have, which is that I believe and I think, while confronting all of our own experiences and point of views, that Africa is really a huge continent, and there is multiples Africa in Africa. Our sources of inspiration, our different sources of law, our different practices, our different histories, even if all of them are joined in this particular circumstances, in matter of arbitration, but in reality we are living and experiencing different situations because we're living in different areas and we are close to different dominant law systems, and our experiences with this regard are, I would say, mandatory different. So it is, there is lots of arbitrations systems, there's lots of ways of each of them to develop, to improve itself. And there's lots of ways of this whole picture to improve on its and each own journey. What I think as well, and Duncan has said it before me, and this for me is very, very important, and it's true for all of us. Arbitration, it is a matter of a long effort. It's a matter of everyday action to build, to consolidate, to maintain a system that is trustable, that is reliable, and this is not the work of I would say even one generation. It takes time to build arbitration institutions because it takes time to build and to bring to the arbitration institutions the confidence and the trust that it needs and that is necessary to its success. And I think that all of us, this is my true feeling, that what I've heard of all our fellow here that each of us in their own practice, we contribute to the construction of this confidence and to the construction of the trust in the arbitration as an institution, which means institution that is indurably, permanently a source of trust and confidence. It is not arbitration today and tomorrow another thing, and tomorrow mediation, and tomorrow other thing. It is arbitration every day, and day after day, this will lead to success as arbitration. So the main key factor for me is the spirit of an institution and the permanent effort to build an institution. And arbitration is an institution among others, and the way institutions are built is it should be it works for others, it should be work for arbitration. And everybody knows here that the big institutions of arbitration worldwide, they are not different, they are not I would say managed by aliens. They are not managed by guys coming from the moon or from Mars. They are managed by guys that build trust and confidence along the years, and that is important.
Thank you, Abdelaziz. Duncan?
I don't have any significant closing remarks other than to say that you see from the comments of the people on this session that there's an incredibly rich source of knowledge and insight from countries across the continent, and it simply demonstrates the extent to which it's an area where in future I think we're likely to see leaders coming out of more and more jurisdictions with the result that parties from the USA, from Europe, from Australia, from the Far East will be interacting with African arbitration practitioners as a matter of course. That's my prediction. It's purely a matter of how long it takes. Thank you very much.
And that's very comforting to hear. Abayomi?
Thank you. I really have nothing more to add. I think a lot has been said by other panelists. Arbitration will continue to grow in Africa. So will third-party funding also continue to grow. But again, to thank you for inviting me to participate in this session and to share the same stage with other panelists. Thank you so much, Ayode.
Special thanks to the Berkeley Global Society under the chairmanship of Urban Gonzalez Lapos for the opportunity to moderate this webinar. A big thanks to our wonderful speakers, Duncan Backshaw. Thank you for joining us against all odds. It's good to hear your voice again. Thank you, Mrs. Fumi Roberts, for your well-cherished insights as always. And to Abdelaziz, thank you very much for your expertise and your detailed presentations. And for Abayomi, thank you as always for your valuable insights. Without you, the panelists, there would be no life to this event. And I also thank all the participants for joining us. Thank you for your questions and thank you for your participation. Of course, without you, we would also have no event. So thank you, Ali Filali, for your background work. And a big thank you to Hema Modi for ensuring that everything went well from the back end. We have come to the end of this webinar. So from me, please stay safe and have a good one.